morning to you both. Doug, after viewing really all of the evidence that was presented, the prosecution really brought a mountain into that courtroom, let's just say. What do you think is the defense's strongest argument here? Is it time, in your opinion, for Robinson to make a plea?
Well, it's hard to say about a plea. There were a few surprising aspects, not substantively, just procedurally about this hearing. I mean, normally a preliminary hearing is pretty much of a relatively quick thing. It's probable cause only. Normally, certainly in my experience, the judge would rule essentially right from the bench. I find that you have demonstrated probable cause. But here they made it into this big thing, almost like a trial. I've been trying to figure out why that happened. I think the prosecutors on some level figured in this particular case, we're going to demonstrate how strong it is, and then also to debunk a lot of these so-called conspiracy theories. To your question, not avoiding it, it's a hard case to defend. I mean, I was a federal prosecutor 9 years, but I was a defense lawyer for 20 years. Okay, and I'm telling you right now, this is not an easy case to defend, but I don't prejudge anything, and we'll have to let it play its course. But I think if the prosecutors were willing to take off the death penalty, with the approval or the input, I should say, of the decedent's widow, you might see a plea like in the Koberger case.
Okay, and Alan, to you now. I mean, again, I obviously don't have the background that you gentlemen have, but I would have to agree with Doug. This is going to be a hard case to defend. And when it comes to the defense, Alan, they chose to not have Tyler Robinson testify on his behalf. What did you make of that move?
Well, I think, with these preliminary hearings in Utah, they have something called reliable hearsay, which is allowed. So that's why you can get recorded witness statements like the Lance Twiggs statements, and you can get statements through investigating officer and other kinds of autopsy reports and things like that that are more permissible than they would be at trial. And remember, when we get to trial, we're going to have all 12 jurors agree for a death sentence. It's got to be a unanimous jury. If one juror votes no, then there's no death sentence. And one sort of interesting thing is that in Utah, a firing squad can be used if Utah can't obtain lethal injection drugs 30 more days before the execution. Then there could be death penalty by firing squad, which would be sort of interesting in that, the Tyler Robinson would die by bullet, having taken somebody's life by bullet.
Doug, we just showed images of Lance Twiggs, the lover, the roommate, whatever you want to call him. And it's interesting to me when you look at him visually here. Very buttoned up. He's got the tie. It seems like he's really downplaying all of the normal images that we see of him. He was in the quote-unquote furry community. He was quote-unquote transgender. Is that a play when it comes to the prosecution side to make him seem more credible? Again, we've heard from close friends of Lance Twiggs that he had various drug problems. And again, he was granted immunity to take the stand. What do you make of the credibility when it comes to Lance Twiggs against Robinson's lover here?
Well, normally, of course, you would argue that there are, potential problems with his credibility. He was granted immunity. That's sort of a standard road to go down. But here, a lot of it's backed up and corroborated, as we say. And anybody in this business for any period of time knows that corroboration is the key with a cooperator. If a cooperator says, Doug Burns and I flew to Atlanta, and that person has very, very poor credibility, but then the government is able to show the plane tickets, the flight manifest. They told the truth on that point. So here, you do have those text messages, which are pretty devastating. I want to just quickly amplify a point Alan made, because he's so right. A lot of information may be admissible at a preliminary hearing, but not admissible at a trial. That was why, by the way, the judge wanted to be a little bit cautious so that he wouldn't necessarily, let's say, affect potential jurors, things like that. But again, this hearing went on way, way too long, in my opinion.
Yeah, no, and I remember you said that last week, that this is very rare for this to go on for the full week, as we saw. And Alan, lastly, I want to ask you about The so-called, quote, inconclusive bullet that was specifically found in the body of Charlie Kirk. It refers to a fragment that was allegedly too damaged to absolutely determine if it indeed came from the rifle that Robinson allegedly fired. The defense, of course, says it proves Robinson didn't do it. Do you think something like this bullet fragment could reach the level of reasonable doubt in the mind of a juror?
Well, again, it's early to say, but I don't think so. I mean, I think we've got all kinds of other evidence in here. We've got video surveillance evidence. We've got a confession to the roommate. We've got DNA linked to the towel and the screwdriver found at the scene. So that that DNA evidence is pretty important. And, we've got ballistics testing, we've got expert witnesses. I think the evidence is mounting, and we're not even to trial yet. So once we get to trial, there could be new witnesses and additional forensics testing and more expert testimony. And so we're only seeing what we're seeing so far at the preliminary hearing. We're not even seeing what may come out at trial.
Yeah, that's exactly. And Doug was saying that exact thing. This is just a small fragment of what we are really seeing of everything. Doug Burns, Alan Mendenhall.